We're here tonight for Civics 101, and our thought is that we all need our civics education refreshed so we can help our colleagues and our friends and family understand a little bit more what's going on. I'm Terry Mumford, and the co-host tonight is Kaz Marganeau, and we are with the leadership development team at Building Bridges for America, along with Jenny Okamoto, who's not with us tonight, but will be joining us for some of our fall sessions. Please keep yourself muted during the bulk of this until we get to the end. But be very active in the chat. Introduce yourself. Where are you joining us from? How did you learn about the program? Are there any campaigns or organizations you're working with? And also let us know if this is your first training. We are part of the way through our 8-session training sessions this summer, and we'll be running this again later on in the summer. You all are, I'm sure, real experts when it comes to using Zoom. So later on, when we're doing the Q&A, we'll be asking you to raise your hand and let us know if you want to be recognized. Kaz and I are volunteers with Building Bridges for America, which is an all-volunteer organization created and maintained so that we'll have better informed grassroots organizers. Here are our mission values and our vision statements. And this session on civics, to me, falls over there in the under the vision, because we are really hoping to have a more engaged and educated electorate who can help us safeguard democracy. I am a retired lawyer. I was a partner in a law firm where I was a lobbyist, and I worked with governmental pension plans around the country. Before that, I was at Indiana University, and before that, at the Indiana Legislative Services Agency. I also was the legislative director for our governor a few years ago, and I was chief legal counsel for the Speaker of the House. So my whole legal career has been in and around government, and so I'm hoping that I can bring some of that background to this presentation tonight. So let's just start talking civics. And the goals of this workshop are to remind us, what's at stake when we vote, specifically in terms of our government structure. What do we need to know kind of at the baseline? What do we need to remind ourselves of when it comes to the Constitution, how legislation comes into being, a little bit about elections, and then a little bit about state and local government structure. We are presenting this training because we think by understanding the system, our governmental system, our political system, we know where to focus our efforts. And we think that we can use this information in whatever role we're going to play in a campaign or in a grassroots movement. Are we a super volunteer, someone who's really at the top, who's helping on policy statements, who's directing other volunteers? Are we a trusted voice? Are we the person who our friends and family come to when they have a question about just what's going on? And are we an engaged citizen? The first thing we're going to talk about is, what's in our U.S. Constitution. We hear on Twitter, we see on Facebook, we see everywhere that something that's happening is unconstitutional. And it's almost as though if we just said that enough, something would go away. But that's not how it works. And what we're going to talk about for a good part of this session is the Constitution and what can be unconstitutional. Because really the only thing that can be unconstitutional is a law, either the law itself, its interpretation, or its implementation. And a law is unconstitutional if it violates an express or implied power or protection under the Constitution. And this is something for us to think about as we move along, and that is, we can say something's unconstitutional. In fact, it's said all the time on Twitter, but we have to be able to find that particular provision or that particular implied power that is being violated before we can say something is unconstitutional. And then the entities that determine constitutionality are the courts. So, what's in the Constitution? Our Constitution is incredibly short. There are 7 articles and 27 amendments. And as we know, the articles were adopted in 1789. And they're not only are there just a few articles, they are all really short. The first 3 articles establish the basic structure of our government, that we have a legislative branch, an executive branch, and a judicial branch, and their roles are defined. The next article talks about how the states interact with each other. And before the Constitution, we know we had the Articles of Confederation, and those the men who were writing the Constitution said, well, we need more definition. We need it to be clearer how the states are going to deal with each other, how they're going to recognize each other and work together. And so in Article 4, we have the full faith and credit concept, which is that states are to honor other states' laws. And one example of that is extraditing someone who has been accused of a crime. The 5th article talks about how the Constitution is amended. Article 6 contains a supremacy clause, which again was a big deal after the Articles of Confederation, a big change from the Articles of Confederation, to say that the Constitution, the US Constitution and federal law take priority over state laws. And then Article 7 is like a procedural article as to how, as is Article 5, as to how the Constitution is to be approved and how it can be amended. And the first 3 articles, as we said, that's where we establish the branches of government and our system of checks and balances. And this system of checks and balances is really what defines our form of government. And it's at the federal level, and we'll talk about it later. It's also at the state and local level. And when we're looking at these branches of government, we are thinking, who am I going to ask to do what I want them to do? Am I going to be going to the legislature for a law to be passed? Am I going to the executive for a law to be implemented? And then am I going to the judicial branch via lawsuits, via lawyers, to put a check on one of the other 2 branches? So as we go through and we talk about some of the things that are happening in our country, we need to think about where's the action, where is it happening, and how, if we want to stop it, do we stop it? When the system of checks and balances was not intended to be easy to work with. It was intended to make it difficult to have things be accomplished. And so as we're working on issues that matter to us, we have to have that commitment, that fortitude to say, well, if I don't get it here, I can get it fixed over here, or I can make an adjustment via the courts, or I can do something through legislation. But we have to be understanding where we are in this system of checks and balances as we're trying to move something forward, or as we're trying to prevent something from happening. Ketanji Brown Jackson, who is now, an associate justice, was talking about in her confirmation hearings, and then before that, when she was on circuit court bench, she has talked and written a lot about this system of checks and balances. And one of the things that she said is that, and we know, is that presidents are not kings. Our system is not set up to have power entirely concentrated in the executive. She said that our constitutional scheme is designed to prevent tyranny. It's designed to have barriers that, in essence, protect the individual. And she makes some, just again, great things for us to kind of to think about and to always have in the back of our minds. Is that she says that, you know, powers are split vertically, which is federalism. So there is the federal and the state government, and they can check each other. And then powers are also split horizontally. Those three branches of government: legislative, executive, and judicial. And the separation of powers, both the vertical and the horizontal, are crucial to keep government from becoming too powerful and encroaching on our liberties. Now, just a couple of years after the Constitution itself was adopted, the guys got back together and they proposed the Bill of Rights, 10 amendments to the Constitution, which were adopted in 1791. And those were additional limits on the power of the federal government. We know, the First Amendment is a guarantee of freedoms: religion, speech, press, assembly, petition. Second is the right to bear arms. And we go through the additional ones related to trials to the judicial branch. And then we get down to the 9th and the 10th, which were, again, they're the writers of the Constitution and the Bill of Rights. They were trying to keep things in balance, and they were acknowledging that they probably hadn't addressed everything that they could have. So the 9th Amendment says, just because we haven't listed a right doesn't mean it is denied. So there can be implied rights. And the 10th Amendment is, again, trying to getting the balance of federalism, is that if the Constitution has not delegated to the federal government a power, or if the Constitution hasn't denied the states a certain power, states have reserved powers. And then just some more amendments for us to think about. We know the 12th Amendment was the establishment of the Electoral College. And then after the Civil War, there were 3 amendments adopted. The 13th Amendment is the abolition of slavery. The 14th Amendment becomes incredibly important. We'll talk about it for in a bit. The 14th Amendment provides protections to the citizens in states. So the idea of the 14th Amendment was to say that a state could not deny someone citizenship, could not take away their privileges, and could not take away their rights without due process and equal protection. The 14th Amendment also contains a section protecting the validity of the public debt. 15th Amendment provided the right to vote to those who had been enslaved. And then the 25th Amendment is the amendment that deals with the presidential inability to perform his or her duties. The very first time we gave this presentation, in the chat, there was a question, but wait a minute, isn't there a 28th Amendment? What about the Equal Rights Amendment? And so just to trace that back just a little bit, as the 5th article of the Constitution says, you can amend the Constitution with the ratification of 3/4 of the states, and that would currently be 38. And the Equal Rights Amendment was adopted in 1972 with a 7-year timeline. Only 35 states adopted within that timeline. But then somewhat recently, 3 states have adopted. So that would take us to 38, but those last 3 did not occur in the 7-year timeline. And I didn't mention on this slide, but there have also been a couple of states, I don't know the number, who have said, well, we've changed our minds. We do not want to ratify the amendment. Well, so where are we? Well, there's a procedural step in adopting an amendment to the Constitution. The federal archivist has to receive the amendment and accept it and say, okay, now the Constitution is amended. And the federal archivist has not done that. And so after those 3 states acted, the federal archivist was sued and again, we think about this, remember, get back to our separation of powers. You have the executive branch, the archivist, not doing what someone thinks they should be doing. And so you go to court to say, dear federal archivist, you really need to do this. You need to accept the ERA. Well, the courts ruled that the archivist was not required to accept the ERA and that Congress could impose that 7-year time limit. So what was the current situation is that there's a joint resolution in the Senate and a joint resolution in the House to remove the deadline and to accept the subsequent ratification. And there's a resource on this page where you can track what's happening with the Equal Rights Amendment. So as of now, we do not have that 28th Amendment. So let's go back to the 14th Amendment, because we're going to talk about that a lot, because this is a limit on state action that came after the Civil War. Because even though the South, the Confederacy, lost the Civil War, after the war was over, those southern states said, well, we lost the war, but we're going to impose all the laws that we want to really preserve as close as we can the institution of slavery. And the Congress responded with the 13th and 14th Amendments, which were then in fact ratified by a majority of the states. And the 14th Amendment, the 2 parts I've highlighted here is, first of all, the part that we're not going to spend very much time on, but it's the part that is, they call birthright citizenship, but where all persons born or naturalized in the United States are citizens of the United States and of the state wherein they reside. And then the second part, which we are going to spend a lot of time on, is that the 14th Amendment says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens, nor shall any state deprive any person of life, liberty, or property without due process, and no person shall be denied equal protection of the laws. Well, that was in there, after the Civil War, but those provisions were in there, but they stayed pretty stagnant until after World War II, when the Supreme Court said, well, and lawyers who brought the cases said, well, we think we can use this part of the 14th Amendment to really expand on protections for citizens in various states. And so here are some examples of how the interpretation and the application of the 14th Amendment has really changed how our society views marriage, for example. We're aware of the Loving case that was in 1967, and the Supreme Court found that a ban on interracial marriage violated the 14th Amendment guarantee of due process and equal protection. And that then struck down all race-based marriage laws in all the states. In 2015, the Supreme Court found that state bans on same-sex marriage were a violation of the 14th Amendment. And again, that struck down those bans in all the states. And just note here that the right to marry is not specifically stated in the Constitution, but courts have characterized it as a fundamental right. So it is an implied right in the Constitution, which then has the protection of the 14th Amendment when it comes to state action. This is also, this protection is also applicable to contraception. We have the Griswold case in 65 and the Eisenstadt case in 72, where the Supreme Court found that first married couples and then any individual has a right to contraception. And this was under an implied right of privacy under the Constitution. Now we get into reproductive rights, and I know all of us are following this, that we know back in 1973 we had Roe v. Wade, where the Supreme Court decided under the 14th Amendment that the right to privacy protects a pregnant woman's right to choose whether or not to have an abortion. The right's not absolute. That case, that case was further modified in the case of Casey, which said that we're not going to focus on the trimester standards, which were in Roe. We're going to look at viability in terms of where does the right of the woman versus the right of the child, where do they come together? And those were decided under the concept of a fundamental right to privacy. And then we have Dobbs, that was decided involving the Mississippi ban on abortion after 15 weeks. And the Dobbs opinion upheld that Mississippi law and overruled Roe and Casey. Justice Alito wrote the opinion, and the majority included, as we know, Coney Barrett, Gorsuch, Kavanaugh, and Thomas. And the decision was based on what's called the originalism history test, which asks us to go back and look at the Constitution and say, well, what did it mean when it was adopted? What did those people who wrote the amendment think then? And that's how we're always going to apply it now. And so how Alito applied that originalism history test is he says, well, the Constitution makes no reference to abortion. That's true. And so he says, well, is there an implicit protection under any constitutional provision? And he says no, because in order for something to be implicitly protected or to be an implicit right, it has to be deeply rooted in this nation's history and tradition and implicit in the concept of order, liberty, and Alito and the majority said that is not the case. Mm-hmm. In the concurring opinions, as we know, in these kind of big cases, will be a majority opinion, and that was Alito's opinion, and it'll say he's writing for the others. But even the justices who concur, who agree with the majority, can write a concurring opinion. And in this case, Justice Thomas said the court should go farther and should look at other rights, contraception and same-sex marriage. And that's because they would be, and his point is, well, if we're going to go back and look at those implied rights that were brought under the purview of the 14th Amendment, well, let's look at those others. Justice Kavanaugh said, well, these penalties, if new laws are going to be adopted on abortion, they cannot be retroactive. And Chief Justice Roberts said, wait, all I wanted to do was uphold the Mississippi law. I did not think there was a need to overrule Roe and Casey. Alito's opinion really put the burden on us, on voters, because according to him, this allows women on both sides of the abortion issue to seek to affect the legislative process. And so again, going back to our three-part chart, he's saying, okay, we the courts have done we, the Supreme Court, have done what we've done. We've struck down we have overruled a prior opinion. We have upheld a state law, and now we're up to the legislative function process to decide what the law will be going forward. In the confirmation hearings for Justice Ketanji Brown, one of our Indiana State U.S. Senators, Senator Braun, stated his opposition to justices who support, in his view, legal activism. And he, like Justice Thomas said, you know, if we're going to look at abortion, we're also going to have to look at other issues, including interracial marriage, because they're all under that 14th Amendment protection of implied rights. And then just a couple of examples of how folks have argued against that originalism approach. Justice Breyer, who retired so that Justice Jackson could come on the Supreme Court, he said, well, it's not the argument in opposition to originalism is really that the Constitution is a recipe. Democracy should work. It is going forward. It is not a painting in a museum. And Justice Jackson said, well, also there's more than one origin. We need to consider the history that surrounds the post-Civil War amendments. And she mentions a case which was actually just decided today or yesterday, the Alabama's congressional maps case. Mm-hmm. So as just stopping here and thinking, our votes at the federal and state and local level matter on these issues, because we have the Supreme Court has taken away a protection of reproductive rights that we've been relying on for 50 years, and we need to be sure that we are realizing that the burden is now on us to be aware of what's happening at the federal and the state and the local level. I want to talk about the Second Amendment, because that is it's another example of how the 14th Amendment has brought a federal protection to the states. And we know that the Second Amendment is considered a protection for gun ownership. But starting back in 2008, the Supreme Court, in a very close decision, another 5-4 decision, decided in the Heller case that the Second Amendment guarantees an individual right to possess firearms independent of service in a state militia. Now, if you've been on Twitter, you know that people in Twitter are very concerned about this state militia issue concept. But unfortunately, the Supreme Court kind of took that off the table in 2008 in the Heller case. And they said the Second Amendment does protect the use of firearms for purposes including self-defense in the home. In the McDonald case involving the city of Chicago, the Supreme Court in 2010, so we're just a couple of years later, the Supreme Court said, well, because of the 14th Amendment, because of the 14th Amendment, the Second Amendment applies to state and local government. And so the idea was they will use the same protections that they were applying in Heller to at the state and local level. Most recently, in the Bruin case involving New York State, last year, the Supreme Court, in an opinion written by Justice Thomas, the Supreme Court struck down a 100-year-old law in New York that had required proper cause for obtaining a license for a concealed firearm. And the rationale that Justice Thomas used was that the New York law would prevent law-abiding citizens from self-defense, and they need that. They need those weapons in order to exercise their Second Amendment rights. The New York State Legislature immediately passed a new law, the Concealed Carry Improvement Act, which contained requirements for the applicant for a concealed carry license to show good moral character. And also this new state law banned guns in sensitive places, such as churches and parks, and on private property unless the property owner specifically agrees to allow guns. The federal trial court held, and there's more than one case, so federal trial courts really held these provisions to have violated the decision in Bruin. The second appeals court, so the next level up, stayed that order, and the Supreme Court agreed not to intervene at this point, but to let the second appeals court consider the arguments. So the second Court of Appeals has still not issued its decision on these cases. The focus has been on the definition of sensitive places. How would sensitive places be defined? And so we are awaiting to see what the Second Court of Appeals decides, and then to see what then the review would be at the Supreme Court. There's more for us to be worried about. There is a case from North Carolina, which had dealt with the congressional maps in North Carolina, and at a certain point, the North Carolina Supreme Court had struck down the congressional map for extreme gerrymandering. The state legislature appealed to the Supreme Court under the independent state legislature theory, which is that because the Constitution gave state legislatures the authority to draw maps, then that authority is really without limit and cannot be overruled by the state courts. It's a very scary proposition. But recently, the North Carolina Supreme Court has reversed itself and has decided it's not going to strike down the congressional maps. So the parties are now arguing that the case should not be considered at all. Let's just not put this issue in front of our particular Supreme Court. So we really don't know what's going to happen. It's the Moore v. Harper case. And what can we do about this? Why, if we're worried about what the Supreme Court is doing, then this slide just says, okay, what we do about it is we remember how, as voters, we affect who becomes the justices on the Supreme Court. We know that the president nominates the justices. We know that the senators are the ones who approve the nominations, and so it's about voting. And then at the bottom we add maybe a little extra practicality here, because there are organizations who are going to court to challenge different state laws, different federal laws, and those organizations need support. They need either monetary or volunteer support. So as we're thinking about what we can do on the issues that matter to us, we are always focused on voting at Building Bridges for America, but we also want to add that bit of reality that there needs to be support for those organizations who are going to court. There's also a question of, how do you fix the Supreme Court? If we have concerns about the 9 justices who are there now, how can we change that? Well, we know that at this point they're lifetime appointments, so someone needs to retire in order for, or not be on the court, in order for there to be a change. That number of justices was set in 1789. And when President Biden first came into office, there was concern as to, what there was this thought, well, surely he can do something. Well, what he did was he got expert advice, and he established a presidential commission to look and see, well, what are the options when it comes to the Supreme Court? And that commission has issued its final report. And here's after, and it's very long, but here are some of the conclusions, and that is that Congress can enlarge the court. They could make it bigger. He cannot. If term limits, such as 18 years was an example, if we want term limits on the Supreme Court, that requires a constitutional amendment. The commission did endorse an advisory code of ethics for the Supreme Court. And the commission also suggested changes in what is called the court's shadow or emergency docket, and that there is a mechanism, there's a procedure where a particular judge on behalf of the court can make an emergency or ruling, an emergency opinion to block a lower court order. And that's one of the things that if you do any reading in this area, one of the interesting facts is that the use of that emergency docket used to be very rare. It is now not very rare, and it is so there's the suggestion from the commission is that there be more more transparency as to how those opinions are issued. But let's talk about some legislative changes, because we're going to have to go to our next topic. There's a workbook that goes along with this program, with this session, and a number of the things that we're going to talk about in the last 15 minutes here are in that workbook. And this is an example where we talk about, what are the steps that you go through to have legislation adopted at the federal level. And you all, I'm sure, are super familiar with this, and you know how that process, how the basics of that process go. The workbook also gives us some definitions relating to the filibuster, the Senate rule that allows a delay in action unless at least 60 of the senators can agree to move something forward. And the definition of filibuster is provided in the workbook. And just to note in there that the filibuster does not apply to what is called reconciliation. It does not apply to the appointment of judges and the cabinet. When we talk about reconciliation, that is a term which has become a very crucial in moving legislation through the US Senate, because reconciliation refers to any measure, a bill or resolution pertaining to revenue, taxes, and debt limit, and that can be approved by a simple majority, 51 votes in the Senate, and that can include a tie break by the vice president. In the workbook, we also have just some basic slides, which if you want to use them, if you have like a group that you want to use the workbook for, we've had some of the folks who've attended the sessions have, sat down with like their Democrat club or whatever and gone through the slides just as a refresher as to, who's in the House, who's in the Senate. This is the, we're going to talk just a little bit about gerrymandering and just kind of get us started. We want to talk about apportionment and how congressional seats are apportioned throughout the United States. And we know that the most recent apportionment was done based on the 2020 session. And the word apportionment means, well, that refers to, how are the 435 seats in the US House divided amongst the states, and they're divided based on population. And this map shows what states lost a seat and what states gained a seat. And then, as we know, after apportionment, then the states, once after apportionment and the states get their number, then the state legislatures draw up the districts for each of those US, let me go back, for each of those US representatives. And that is where we get the idea of gerrymandering, because it's in the drawing up of the districts that there is the concern about, are the districts being fairly drawn? And this slide just reminds us it's not too early to plan for 2024. Every member of Congress will be up for election, and a third of the US senators will be up for election. And we're just reminding you to, it's start now checking on your senators, your representatives on their views. And also just a reminder that in 2 weeks, we'll have another course on Civics for Change in order to write to or communicate with your elected official. If we're looking at the elections, we have in the workbook, we have another couple of sections on definitions on, again, this would be, if you're really talking to a group who you think, boy, we really need to start at the beginning, this might be a good place for you to start. My younger brother taught a college course in government, and it was a spring semester, and he asked the students how many of them were planning on voting in the primary, because in Indiana, our primary is in May. And there was just nothing happened in the class. He asked them the question, nothing happened. And then he said, okay, how many of you know what a primary is? And only a few hands went up. So if you're dealing with a group where you think they need this level of as a starting point, we have that for you in the workbook. We also have some definitions that may be helpful. And we talked here on this page, we have the definition of gerrymandering, which is the practice of drawing political constituency maps to increase a particular candidate or party's advantage. And then we go on to talk about the administration of elections. I wanted to just stop here for a moment on the gerrymandering, because I think gerrymandering is something which, well, in Indiana, we are very concerned about it because of how our congressional maps are drawn, how our state house for both the representative and the senators are drawn. There is a mechanism for challenging gerrymandering under the Voting Rights Act at the federal level. And the Supreme Court just yesterday, decided a case coming out of Alabama that was referenced at the very beginning by when we were talking about Ketanji Brown Jackson, that the Supreme Court found that it was likely that Alabama congressional maps had disenfranchised Black voters, and that would put the burden back on the Alabama legislature to draw what in essence would be a second majority Black district. So there are ways to challenge gerrymandering. If we want to use the Voting Rights Act, it will have to be solely on the basis of discrimination on account of race or color. The other ways to challenge gerrymandering are, the burden is very high because you have to get to a standard of a violation of equal protection or due process. Those of us who are, active in getting out the vote, and particularly those of us maybe in Indiana, maybe in other places, are we certainly run into the argument that because of gerrymandering, my vote just doesn't matter. But we have to respond to that. I mean, gerrymandering is a problem, but we have to respond to that and point out to folks that that issue of gerrymandering does only apply where there are districts. If we're talking about statewide races, countywide races, the gerrymandering concept isn't there. So let's get out the vote. But also, even when we are thinking we're dealing with a situation where gerrymandering is a problem, we still want to encourage folks to get out to vote, because we want to avoid the mandate of the elected official saying, I have a mandate. Look at I should be able to do whatever I want. And we just ask you, and we're going to later in the year, we're going to talk more about this, is we ask you to become an expert on the upcoming elections in your state, who's on the ballot, what's your last day to register, et cetera, and how can you get out the vote. In the workbook, we give you an example of the structure of state government, and it's our home, Indiana. And one of the things that comes out when you're looking at this example, the Indiana example, is that Indiana is a state where at the state legislature, in both the House and the Senate, there is a supermajority of Republicans. And a supermajority means that the Republicans do not need the Democrats to even show up in order to take action. There are enough Republicans that they can constitute a quorum in each of the houses. And that's also true in terms of the membership of any of their committees, that committees can take action if only the Republicans are present, because the Democrats cannot break the quorum. And so if you're thinking about your own state, try to look at that issue, because one of the things we ask you to do is use this description of Indiana as a template for understanding how the branches of government in your state work. If you are looking at the branches of government in your state, you will notice that there are the three branches: the legislative, executive, and the judicial, and the state constitution follows that federal governmental structure. And as we know from the very beginning of our presentation, the state constitution cannot be in conflict with the federal constitution. It can cover areas that the federal constitution does not cover, can offer greater protections, but it cannot be in conflict with the state constitution. The other thing I would suggest is, when you're looking at your state structure, is to decide, or not decide, but to figure out whether or not in your state the governor is a strong governor or not a strong governor, and the deciding factor, is how many votes does it take to overrule his veto. For example, in Indiana, if legislation passes the House, passes the Senate, and then comes to the governor's desk, he can veto it. He can sign it, he can veto it. But if he vetoes it, it can then go back for an override in the two chambers. And only a simple majority is required for that override. And so if you're looking at your own state law, figure that one out. Do you have the weak governor system or the strong governor system? One of this slide is talking about what powers have, under the 10th Amendment that we talked about, what powers have traditionally defaulted to the states, and ownership of property, education of inhabitants, insurance, and then that listed there. And then we talk about, what's that balance? Because there's a check and balance from this is the vertical, that at the federal level, we have the supremacy clause saying that the US Constitution and federal laws preempt state laws. And we also have a separate interstate commerce clause, which says that the states cannot take action which interferes with interstate commerce. So homework is to, using the workbook, would be to prepare a chart of the structure and the office holders in your state government, and particularly if this is a municipal election year, which it is in Indiana, chart out your local structure, and then as an individual and as maybe a member of a group, figure out who is your state representative, your state senator, your city councilor, and then what are their positions on issues that are important to you. In the upcoming session on Civics for Change, which is in 2 weeks, we talk a lot more about that, and we have examples of charts that you can fill in to complete that task. And then, how can you use this knowledge? Well, it's, in canvassing and phone banks. You can be a poll worker. You can be a network resource. Just, there are ways when this, questions are going to come up, and you can be that super volunteer. You can be a trusted voice. The example we gave here is that they did an informal interview about what are the roles of the Indiana Secretary of State, what are the duties, responsibilities, and 4 out of 335 people knew that the Secretary of State was responsible for elections. And we decided that was a distressing statistic, but it shows that you could have an impact if you share your knowledge. So we have some resources for you to consider: what's happening at the Supreme Court, who's on the ballot, how you track legislation. And then in a couple of weeks, you can sign up for Civics for Change. You can always sign up and learn more at Building Bridges for America. And now, discussion.
That was great, Terry. We had great discussion going on as well. So thanks everyone for keeping that chat going and asking great questions, most of which were, kind of discussed as a group. Okay. One piece of breaking news was that Trump has been indicted on federal charges. So if you are interested in that, you might want to go run and go get that up to date information. So we can celebrate along with the rest of us. It's interesting. Here we're talking about checks and balances and stuff like that. And here we got the court case that is coming along, that will now be coming along, which is great to see. And then we did have some questions out there. There's one question, I guess this kind of ties into, going into our next course, but Karen asked, she direct messaged me, so I hope, Karen, you're okay with me asking this to everybody, but she says, how do we encourage our high schools to teach civics to all children, including how to identify your representatives, how to learn their views, and how to fill out a ballot? What is that process to encourage our high schools to teach this?
Well, I mean, I am old enough that when I was in high school, so we had to take a government class in order to graduate. At that point though, the government courses were taught by like the baseball coach and the basketball coach, because they had to teach courses as well as coach. And it was one of the very simple things that they did, because it didn't take any work on their part, was to have us fill out one of those charts. One of the tests was, who is your mayor? And it was so, it was an easy A, but you did also learn who your mayor was, and and who the governor was. As much as I think this would be, well, first of all, in Indiana, that type of the curriculum is set at the state level. So you actually would go to your Department of Education, the Superintendent of Public Instruction, and you would ask that the high school curriculum include government, and that it include that type of information. And also in Indiana at the state level, the textbooks, there's an authorized list of textbooks. So the content of the course and the content of the textbooks is set at the state level. I don't know from state to state if that's always true, but that would be in Indiana. That's what you would do, is you would go to the Department of Education, Superintendent of Public Instruction. You can also ask your school board to have them ask for that kind of for those courses to be on the curriculum. And then I suppose the school boards could have elective courses.
Yeah. So a lot of it, that kind of ties into the next course. So the Civics for Change would walk you through how to find who is the one that is in charge of the issue that you're having, right? So, oftentimes, if we don't really understand civics and how things work, then we end up asking and pushing the wrong elected officials, people who really don't have any kind of authority over this, to do this. So it's good to know that, it's either your school board or back to your state legislator. A lot of it falls onto that legislative process.
Yeah, and then here. Yeah. Molly says that civics is required in Ohio for seniors. So yeah,
that's great to hear. Yeah. I mean, in high schools is great. Although, I mean, just across the board. I mean, if anybody's ever been out, talking with voters and knocking on doors, it's just really surprising how little a lot of people know and think and care about politics. For the most part, people can name maybe 3 politicians, not their own mayor, but maybe 3 politicians. Maybe they can think of, Trump and Biden and maybe one other, that's where most people are at, so I like to, constantly be reorienting myself back to where most people are at. And that's why I like this course, because it kind of boils it down to those really basics that I can then turn around and explain to others, when they feel frustrated, when they don't know why things work, they don't know why their vote matters. Why does it matter who my state legislator is? I don't know who they are. Well, it matters because you can walk them back to these their core rights, these core rights that are now being threatened, if not being removed. So, well, we're at 9:02, so I don't want to keep people too late. And like I said, we do have exciting indictment news to go read and go run to. But yeah, so if anybody, unless anybody else has a question that they want directly asked, I think we're going to say have a good night, and hopefully you can join us next week. Next week on Thursday, let me put a link in there. On Thursday, we have Pop the Disinformation Bubble. So if you are wondering, if you see a lot of disinformation out there, you're wondering how to navigate this new modern world of media, and also then turn around and help others when you hear and see others that are believing these lies. That's what we're going to cover on Thursday. And then the week after that is then we're going to have the Civics for Change. So taking this and then putting it into practice. So thanks, everyone. Thanks so much for joining us. And yeah, happy news watching.
Thank you very, very much. I'm very grateful. Thanks.
All right. Have a good night, everyone.